responsibility to exercise oversight over state agencies under its jurisdiction. The primary purpose of this review is to assess the effectiveness of these agencies in protecting consumers and to determine whether changes in the law or in their operations or functions are necessary. Today, we will be reviewing specific issues regarding the Department of Consumer Affairs, the Board of Registered Nursing, Board of Vocational Nurses and Psychiatric Technicians, the Dental Board, and the Athletic Commission. We will also hear from the Attorney General's office regarding their prosecution of disciplinary cases for boards. To assist members in their review and evaluation of each agency, committee staff has prepared a background paper which identifies issues and makes staff recommendations for each agency. This paper has been posted on our website and is made available to all interested parties. Committee staff has also asked each agency to focus its comments on the more critical issues that have been raised. We will ask each agency to begin their testimony by providing members with a brief overview of their programs and to respond to the more important issues raised by staff. Members will also have an opportunity to raise any other issues or questions they may have. We will also hear from consumer groups, professional organizations, members of the public, and so everyone will have an opportunity to weigh in. Some of these persons appear on the agenda. Others who would like to testify will be provided an opportunity to speak. As we begin, I'd like to recognize members of the committee who are with us today. Our Vice Chair, Bill Emerson, and Mimi Walters. Either of you care to make a statement? Comment? All right, well, let's get this ball rolling. We're going to see how far we can get by 12. We're going to adjourn and go to the floor. Then we shall resume after. But why don't we begin with the Department of Consumer Affairs and have the Acting Director, Mr. Brian Steiger, join us. And colleagues.
Good morning, Mr. Chair, members of the committee. I'm Brian Steiger. I serve as the Director of the Department of Consumer Affairs. And I brought a couple of colleagues with me. On my right is Kimberly Kirchmeyer. She's Deputy Director for Board Bureau Relations. And on my left is Mr. Paul Riches, Deputy Director for Enforcement and Compliance. And it's a pleasure to present before this committee this morning. The Department of Consumer Affairs is comprised of 37 regulatory boards, bureaus, and programs, and together we license about 2.5 million individuals and businesses in more than 240 different categories. We ensure minimum levels of competency for our licensees, and we enforce laws that protect consumers. We investigate alleged violations of the law, and when we find clear and convincing evidence of serious violations, we work closely with the Attorney General's office to suspend or revoke licenses. When I came to the department as a director in August of 2009, I immediately saw the need for far stronger enforcement oversight of our boards and far greater accountability of our boards to the department and to the public. Those two areas were and are my top priorities. The need for these improvements was made apparent in a series of high-profile media articles which accurately reflected serious deficiencies in the Board of Registered Nursing's enforcement program. When I was appointed as director, I found that the Board of Registered Nursing wasn't alone. After I ordered a review of the other 16 healing arts boards, I found similar problems in most, if not all, of their enforcement programs. And as a newly appointed director, it was my job to fix it. My first actions were to make sure that the boards clearly understood that their highest priority is protection of the public. We knew that we couldn't make piecemeal changes to fix these serious problems that have plagued the department for years. We needed a new system, a system that is contemporary, comprehensive, and cost-effective, a new system that all 37 boards, bureaus, and programs could implement quickly and completely. Our solution is the Consumer Protection Enforcement Initiative. CPEI is a three-pronged approach designed to reduce the time it takes to suspend or revoke a license from 3 years to between 12 and 18 months. This is an aggressive goal. However, it is realistic, reasonable, and consistent with our public protection mandate. CPEI consists of administrative improvements, staffing augmentations, and additional enforcement authorities. Since its inception, CPEI has already resulted in several notable successes. The department is now a results-driven organization. All of our efforts are focused on meeting the 12 to 18-month time frame. We developed performance measures, improved board governance, and trained our staff on the use and value of collecting data to analyze and improve business processes. We have made performance audits a standard business practice. We are now conducting enforcement audits of all the boards and bureaus as part of CPEI. Once those audits are completed, we will follow up to ensure the boards and bureaus implement all of their recommendations. In reviewing the enforcement process, I found that the Division of Investigation was not meeting the needs of the boards. We applied the same strict oversight to the division as we did to the boards, including hiring a deputy director for enforcement and compliance to oversee the functions of the division. We also established strict performance expectations for the division, which will be posted on our website later this week. We have made significant reductions in the time it takes our Division of Investigation to investigate cases. For example, 2 years ago, we had 580 investigations over a year old. Today, we have 3. The average number of days it takes to investigate cases has fallen dramatically from 476 days 2 years ago to an average of 221 days today, and it continues to drop. Our goal is to complete all investigations on average within 180 days. 2 years ago, the division had over 1,500 pending investigations. Today, we have 810 pending investigations. In order to ensure staff had the proper training to achieve these accomplishments, we started an enforcement academy to train staff on the entire enforcement process, including probation monitoring. We're also changing the way we monitor substance abusing healthcare practitioners. I have made it abundantly clear that every decision we make in this area must be focused on our primary job of protecting the public. Our healing arts boards are well on their way to implementing uniform standards for monitoring substance abusing healthcare practitioners pursuant to Senate Bill 1441. The boards are incorporating these standards through the regulatory process. My office will continue to attend board meetings and closely monitor the progress of these regulations all the way through final adoption and, more importantly, implementation. The department performed an audit of Maximus, an independent contractor who monitors substance abusing licensees in diversion programs for 7 of our healing arts boards. Our audit found areas of concern and made several recommendations. Additionally, we investigated a serious breach of testing standards. Although we found that the contractor is currently tested within the required ranges, we will continue to review their performance on an ongoing basis to ensure they comply with the requirements of the contract. I believe there is much more work to be done relative to the effectiveness of the board's diversion programs and their contractor. While I'm confident in the department's ability to conduct routine performance audits, I have concluded that we need to seek the services of an outside agency that has the requisite expertise and experience to audit and evaluate diversion programs. Our healing arts boards are beefing up their enforcement authority to revoke licenses for sexual misconduct, banning the use of confidentiality agreements in court settlements, imposing sanctions for failing to provide documents necessary to an investigation, imposing sanctions for failing to report an arrest, and authorizing the board's executive officers to sign stipulated settlements to revoke or surrender a license. We're also using new business practices. The department is using more non-peace officers to investigate enforcement cases. This is a change in some boards that some boards have already implemented and others are preparing to move forward with. This hybrid workforce will assist in the reduction of timeframes and the reduction of overall enforcement costs. We are currently involved in procuring a new database called BREEZE. BREEZE will modernize and combine 2 antiquated technology databases, which will improve management of our enforcement and licensing systems. BREEZE will provide applicants and licensees the ability to do much of their routine business with us online, saving both time and money. BREEZE is being acquired using a procurement model that is results-oriented. We will not pay one single dime until the system is built, operating, and doing what we want it to do. This dramatically minimizes the risk to the boards, department, and the state, since no money changes hands until the system is operating the way that we want it to operate. We've also made tremendous improvements in our licensing processes using the same results-based management. As a result, nearly 80% of the department's regulatory entities are reviewing and approving applications within 30 days of receipt. We have accomplished all of this with the resources that began dwindling soon after I returned to the department. Now, that's not to say we don't need to fill key positions, because we do. But once we have those additional resources, they will be stepping into a much improved, more functional environment and will help accelerate our rate of improvement. If I had to sum up how we've made the gains we've made. I'd say that the system we had when I returned to the department was perfectly designed to give us the results we were getting. But once we had to change the results, we had to change the system, not merely tweak it to make the system more efficient. We also learned that oversight matters, and that's the responsibility of the director. Whether it's collecting and posting performance measures for all of our boards, bureaus, and programs, vetoing regulations that erode consumer protections, posting accusations on our website after a board refused to post them on their own, rejecting the appointment of an unqualified executive officer, or insisting that prescription labels be written in type large enough to be read, strong enforcement has been a constant and critical component of our overall success. My office has attended nearly every board meeting that has been held over the last year and a half. At these meetings, we engage and, if necessary, challenge the boards on policy issues to ensure public protection is paramount. We encourage the members to take a very active role in the oversight of their board functions. We have made every effort to ensure that board members know their role in oversight and governance. It is clear to me that we will have to continue innovating. We cannot conduct business the way we used to. The resource picture has changed, and we will have to continue to meet our consumer protection mission with reduced resources. We still have a lot of work to do. We must improve the delivery of the department's administrative services to more effectively support the board's operations. The board should not have to use their own precious resources to make up for the department's responsibilities. To enhance consumer protection, the boards need to move from a passive continuing education model to adopting continuing competency requirements. And of course, there are areas outside of the department's control which we believe would assist us in performing our job better and reduce costs. We need the authority to contract with collection agencies to collect outstanding cost recovery monies and monetary fines. Provide authority for the director to place items on a board's agenda. Providing boards the discretion to have reinstatement hearings by committee or via paper receipt. Allowing boards to use electronic means to post agendas and meeting materials. And we should let boards hold their meetings in Sacramento rather than requiring them to meet throughout the state. These legislative changes would save costs at the boards and improve the department's oversight function. I want to thank you for the opportunity of being here, and I'm happy to answer any questions that you may have.
Thank you. Thank you. I'm joined by Senator Vargas, Senator Cloud, Senator Hernandez. Any questions, members? Anyone? Mr. Hernandez?
Thank you, Mr. Steger, for being here this morning. I have a couple questions with regard to your BREEZE, the database. Can you explain to me, is that going to encompass for all of the boards that are under the state of California with regard to what kind of information is going to be in there? How is that going to be implemented? And is it like all of the licensees that will be under one standard database?
BREEZE will be limited to the Department of Consumer Affairs and all the boards and bureaus. There'll be a lot of information in the database with regards to licensing and enforcement. Licensees will have the ability to renew their licenses online, but I also have Ms. Kirchmeyer, who might be able to provide a little more information with BREEZE.
Thank you, Senator. In regards to BREEZE, the other thing that it will provide, one thing you were asking about, is for all the licensees, it's going to be basically a one-stop shop for a consumer. They're going to be able to go out there and look into the database and see if an individual is licensed by any of the Department of Consumer Affairs boards. It's also going to provide access for the consumer online. They're going to be able to make a complaint online, follow the review of that complaint, as well as for an applicant, they're going to be able to submit their application online. For a licensee, they're going to be able to renew online, and all that's going to be able to be viewed. It also will allow the boards to communicate together, so they'll be able to talk to each other, which hasn't been able to be done in the past.
Now, is the information for each board and or profession going to be the same? Obviously, name, address, where they practice, where they live, ethnicity, demographics, the whole bit. Is it going to be standardized, or is each board going to have its own set of criteria?
It actually is going to be standardized. We've actually developed it's called a forms revision work group that is looking to make sure that each component that and an individual board has, that it meets the standard criteria. So the name, everybody would be putting it in the same way. Education, everybody will be putting it in the same way. Now, obviously, some boards have different criteria where that would have to be individualized, but the overall look will be the same throughout all the boards and bureaus. That's what we're trying to standardize.
Now, what about the renewal cycles for all the different professions? Are you going to try to get them also to kind of go out at the same time when they renew for that particular month, whether it be on their birthday, et cetera, to kind of standardize that as well?
We actually haven't looked at that right now. For most boards, their renewal period is bi-yearly, so they pay every 2 years, and it's by the month of their birth
Their date
date.
of birth, correct.
Yeah.
Okay. Now, is there a way for us or for the legislature to get involved with kind of the structure of the makeup of the questions that are asked? And I guess the reason why I'm asking is because I have a vital interest in workforce. And in order to address the workforce shortage that we have in the state of California, we need to, first of all, find out where the providers are, where the demographics, where the lack of access is, and is there a way for the legislature to work with the Department of Consumer Affairs to be able to make sure that we get all those questions asked correctly?
Well, Senator, I think there absolutely is a way. We have been working very closely with OSHPAD in the collection of their data for workforce assessment and development. We believe that if there was a legislative mandate for many of our programs to provide that information, we think that would be a big step in the right direction.
Okay. And then one final question with regard to continuation or continuing education or CME and continued competency. Where do you see the timeline when you're going to start transitioning from the CE model to continuing competency? And I also see that there's going to be probably some pushback from a lot of the provider groups because it's a different way of how we're going to educate or re-license our members.
It is. We have, over the past year, looked for ways that we can proactively protect consumers, and we have found that continuing competency, again, is a step in the right direction. We're beginning to work with our boards to enter into the discussion. We're having speakers come out, and we're doing some research right now, but it's something that is, a short-term goal for us, and we're hoping to move in that direction in the next, 12 to 24 months.
Is this something that you're going to be doing, like pilot projects for specific boards first? Is this a direction that the administration is taking, or is this something that you're going to be looking for legislative authority as well?
At this point, we're actually encouraging the boards to move in that direction on their own. We have 3 boards at the department right now that have implemented continuing competency. For example, the Board of Podiatric Medicine, they've been involved with continuing competency for about 10 years. And interestingly, their consumer complaints have dropped by 50%. Whether or not that's a direct result of continuing competency, I'm not sure, but it certainly has some impact.
And what kind of pushback have you had, if any, from the various professions? Or I'm assuming that's something that they'd be very lukewarm to or not very receptive to.
At this point, I haven't received any pushback. I've received some concerns and some questions, but at this point, I think people are actually waiting to see what type of policy direction that will come out of the department and how the boards actually take up these issues at their meetings.
Thank you.
Just want to thank Mr. Steiger for all the work he's done in the last 2 years.
Thank you, Senator.
Yeah.
Thank you very much.
Lots of issues raised in the Division of Investigation about the length of time it takes to get a case through the process. 18 to 20 months sometimes is standard. I know you've got a very aggressive goal of reducing that backlog to 6 months or so. How do you intend to do that with budgetary constraints, fewer personnel? What's the strategy this time? It's going to be different in resolving the backlog.
Sure. A couple of things, and I'll let Deputy Director Parwich also answer this question. The staffing levels at the Division of Investigation actually has been higher now than it's been in several years. They've done a really good job of recruiting and retaining their personnel. They've also taken a different approach to how they prioritize cases. They took an approach to look at all the cases that were over a year old and change their priorities to the point now where their average time it takes to investigate a case is about 220 days. But the primary, I think, work that has been done has been really at the deputy director level. So I'll let Mr. Riches provide additional information.
Good morning, Senator. There's a number of things that are working in our favor. First of all, we are, as the director said, excuse me, at 220 days now, which is about 8 months. We were at about 18 months 2 years ago. So we've already made significant inroads, and part of that has been reducing the overall number of cases pending. Part of what had happened is over the years, a huge number of pending cases have built up, and we've had a lot of success in clearing that pending out over the past 12 to 18 months. So we're now down to carrying about 800 cases, basically half as many cases pending at the division. So that's that step. The other is, as the director referred to, we have brought staffing levels, even in the recent budget environment, up from what they were. When I was an executive officer at the Board of Behavioral Sciences, routinely the division had in the mid-20s in terms of field investigators working investigations for all the division clients. We've been traveling in the mid-30s for the past year, and we've been able to keep that number steady, and that has made a huge difference to be able to address the backlog, because the backlogs had developed over time because of vacancy rate. Lastly, moving forward, I think there's a lot of opportunity to improve this. First of all, the hardest work is behind in terms of clearing that large pending. Second of all, as the division has been operating under furloughs for the past 18 months. If we get bargaining agreements resolved and remove that restriction, that's going to bring in a significant additional number of days to the division to work cases. And I think we are within very close striking distance of 180-day average closure time based on those factors.
And talk about the relationship with the Attorney General's office and other agencies. How has that process been streamlined in terms of pursuing cases, completing cases, following up investigations?
Yes. Since we've been there, we worked very closely with the Attorney General's office, both on the licensing side and on the quality assurance side. We're all sort of scrapping for resources, but we have worked together to set priorities, also make sure that our cases are have a high enough quality when they go over to the Attorney General's office. They don't have to do too much work to them. It's not to say that we can't make improvements, because we can. Part of getting to our 12 to 18 months, we're going to need to make sure our investigations are completed quickly, and the Attorney General's office is able to do their work within 8 or 9 months. So it's a work in progress. We're going to continue to reach out to the Attorney General's office and also to the Office of Administrative Hearings.
Any other questions? Well, thank you, Mr. Steiger, for your testimony. Your colleagues, you all have done a great job in turning around a situation that was looking more grim, I should say, a year or so ago. But I think that you're adopting the kind of approach that's going to be important, and we appreciate your testimony today.
Thank you, Mr. Chair.
Thank you. And a perfect segue to the Attorney General's office. Our next presenter, Karen Chappell, Supervising Deputy Attorney General.
Good morning, Senators, and thank you for the opportunity to be here today and to address you and to participate in this conversation about how we can improve the quality that we give to the consumers in California, and how the Attorney General can assist the client agencies, the 37 client agencies that we represent, in fulfilling their mission of public protection. Today I'm appearing on behalf of my supervisor, Alfredo Terrazas, who is on a well-deserved vacation. It occurred to me this morning that the last time I came in August of 2009, my boss was also on a well-deserved vacation, and he hardly takes a vacation. It just turns out that it's when he comes, when you guys convene a hearing. So I have a PowerPoint presentation that's designed to show, this hearing is about efficiency in processing the disciplinary cases and the transparency with which which they are handled. And I'm proud to say that we're very efficient in terms of the work that we do for all the client agencies, and the whole process is very efficient. I think the majority of the client agencies that I see represented here, the three that are up for sunset review, well, the dental board, the vocational nurses, and the athletic commission, Alfredo does meet with the EOs of those agencies, all the EOs for DCA regularly, and they have met together to talk about developing an IT program that the data that we use, they're communicating with the same language. Because the Attorney General's office, we have ProLaw, DCA has something else, they're developing Breeze, and I know he's been working on that, and so that's the transparency aspect. So these are the 4 keys to the disciplinary process. I can speak to the Attorney General's portion. It starts at the Division of Investigation, where the intake and assessment, the priorities of the cases. The last time I was here, I appeared before Senator McLeod, and we talked about the backlog at DOI, and we recommended that we give a liaison deputy to that agency to help get in there and break up that logjam of cases and stop it from reforming. And you just heard Brian Steiger's testimony that, in fact, that has happened, and Mr. Riches as well indicated that the backlog has been reduced significantly. Then it goes to the DCA, and then they send it to us. Now, when they send it to us, we have a lot of things to do. The investigation is normally complete. We have to assign it to a deputy, plead it, and get it filed with the agency. After it's filed with the agency, then a number of things can happen. Respondent can answer, in which case you're going down a litigation track. If they don't answer, then we're going down a default track, and we're working with particularly the nursing board to develop the exact protocol to expedite that process. And then, of course, if it goes to trial, then we send it to OAH, and they are backlogged based on the furloughs. I think if we put in a request to set at the Office of Administrative Hearings today, we'll probably get a trial date someplace in September, and that's in Los Angeles. Of course, that's the largest office, but with their furloughs 3 days a month, they're backlogged pretty much. The assigned liaison DAG has been a huge difference in our office. That is personalizing 2 huge government entities, our office, the Office of the Attorney General, as well as each individual agency. We assign a liaison deputy to an agency to help them prioritize their cases, talk about the best way to move them forward. They typically remain the same, even though EOs may come and go. And we found it's been great. And with some agencies like the Nursing Board has 300, I think almost 380,000 licensees. So we give them 2. They have a liaison in Northern California and Southern California. They do a tremendous job for that agency and for our office. They act as a conduit, and they also advise our deputies and the client agency on the new laws and statutes. So let's just get to the numbers, because my boss loves numbers, and he gives me this stuff to deliver to you guys. So I'm just to put where we are right now in context and show you how things are trending down. We've gone back a couple of fiscal years. So the total number of open cases in our office in FY06 was 2615, which is a big number. We had 90 deputies statewide at that time. Now this shows the number of cases office by office, and I'll just give a shout out to the LA office, since that's the one I'm in charge of. We have the most number of cases. Those deputies do a tremendous job. This slide shows that our largest client agency in 06 was the Contractor State Licensing Board, and the Nursing Board was the second with 17% of the work that we do. And moving ahead to 07, you see how the trend is upward with up in the upper yellow, 2,843 cases that we have. These agencies that we represent is just that's a partial list. We have 37 different agencies that we represent. And again, now you can see that the Contractors Board cases are fewer, but the Nursing Board cases are coming up. Now in 08, we're up to 3178 on our cases. And Nursing Board cases are up to 22%, and the Contractors Board cases are coming down. The Dental Board cases, we just don't ever get too many cases with the Dental Board, not as much. 3,500 cases in 09-10 in our office total. Okay, 1,200 of them are in LA. Now, Okay, you see what happened after those the hearings that you guys convened in 2009? Look at the nursing board cases. Those are the cases that came over from DOI after we went over there and helped break up that logjam. 28% now they're up to. Okay, now the number of days, how many days? Can we get it down? It's trending down. Look in 165 days in 07-08 to where we are just now, fiscal year to date, 50 days for the nursing board, 59 for the dental board, 73 for the vocational nurses. Okay, and there's another chart just to show you on the graph how it's trending down. We're very proud of that number, particularly with the few amount of deputies that we have, which number has not increased. Now, those are all the normal cases that we do, a regular disciplinary case. In addition to that, the Attorney General's office handles emergency requests from agencies, like PC-23s if the licensee has been arrested or convicted of a crime, and the interim suspension orders if what they've done is deleterious to public health, but maybe doesn't rise to the level of a criminal act. So we can, based on declarations, go in and ask an administrative law judge to have their license suspended pending the outcome of a disciplinary hearing, and that basically expedites that process. So you can see the use of that tool by the three agencies that you're looking at today, certainly with the nursing board, has trended upwards from 1 back in 07-08 all the way up to 8 in the last fiscal year, but in our office, ISOs were 16 with all the other agencies combined. And you can see, particularly with the nursing board, they are availing themselves of this particular remedy because it's efficient, it's effective, and it is very cognizant of public safety. And for our section total, we have 16 right now. It's kind of an irregular trend because ISOs, you say, sometimes it seems like it's costly because we have to do a lot of upfront work, getting all the declarations, interviewing the witnesses. The investigation takes place up front in a very compressed time period. But when we've looked at the numbers in the long run and you compare it to a regular accusation, overall it's about the same amount in terms of cost factor. These are the PC-23s. This is when someone's been arrested. We try and get in there at the first time that we are able to appear in a criminal proceeding. Now, these cases are crazy because they come in at the last minute. Sometimes I'll get a call in my office. It could be 4:30 or 5 o'clock, and the case might be in Bakersfield, Riverside, San Bernardino. So I just grab our list of deputies and see who lives nearby and who can be tasked with it, and it's like a hot potato. Sometimes I have to do it myself. So what happens is you just grab whatever kind of paper.
Mr. Terrazas, tell me you're on vacation.
No, I'm going to give it to Alfredo next time. I had to do one recently for the city of Bell. Believe it or not, one of those city councilmen had a license with the Cemetery and Funeral Board, so we had to go in and get a PC-23 on him. And so in those cases, we're operating, that's relief that gets turned around within a 24-hour period of time. And as you can see, we have 65 of those in our office right now. 11 of them are for the nursing board, and that's just another really effective tool. And I don't know, 65 criminal actions against licensees, that seems like a lot to me. I don't know if that's because of the economy, and I don't think they're all in the city of Bell. Okay, so PC-23s open in the section is 65. Okay, now here's the total. Now these numbers are really amazing to me because the total number of cases that were in our office in 07, 2841, versus what we're projecting on a straight line projection at the end of this fiscal year. I think we're 3/4 of the way into it. We're projecting 4,804 cases by the end of this year. Right now, 3,003 new cases just through February 16th when these numbers were pulled from ProLaw. And this is how many new cases open per agency. You see the nursing board has 949 new cases. That's a lot of cases. That's a lot of cases. But they're clearing out that 1,500 backlog that they had when Senator McLeod convened the hearing the last time. And as you can see, that's a really sharp trend up of cases in the Attorney General's office. Now, here's our staffing during all of that time. While the cases were steadily going up, you can see our staff kind of remained just the same. In 10, 11, we've increased our staff by 5 positions. That's 5 deputies. basically. So it's, that line is a straight line. The case line is going up. So the life of a case, the average number of days to pleading. So here's the calendar. So say we got a case on March the 1st. Okay? If it was a dental board case, that case would be filed in 50 days, according to the data in ProLaw that we have. So that case, if we got it on March the 1st, we'll be filing that on April the 19th. And we'd be filing the dental board case on April the 28th. And the vocational nurse case would be filed on May the 12th. So 50 days might sound like a lot, 73 days might sound like a lot, but you look at the calendar, it's not really that long of a time. And again, we're just tracking the amount of time that it's the case that we have responsibility over what happens to that case. Once it goes to OA8, not so much. Okay, what does this graph shows that our workload has increased 69.1% over the last 4 fiscal years, which is a huge increase. And our staffing has increased by only 5%. Concurrently, the number of days that it has taken us to plead a case has decreased by 63%. It was taking us 165 days to plead. Now, this is an average of the vocational nurses, the dental, and the registered nurses. 165 days is what it was taking us in 07-08, and we're down to 61 days. 63% decrease. I think that we're working very efficiently. So Alfredo always tells us that we have to work quicker, faster, better, and so I think that these numbers in ProLaw show that we have managed to do that. We've had an increased number of cases, no significant increase on our staff, and we've just decreased the time for filing. And, you know, that's just based on efficiency, prioritization. Whenever there's a problem like with the nursing board, if there's a huge negative media campaign like that they were facing before, we prioritize those cases, and keeping in mind that we do have 37 different agencies that we do the work for. And thank you very much for your time, and I'm happy to answer any questions that you may have.
Lots of good numbers up there, and I'm just always taken by the number of consumers, number of citizens that are impacted by these figures. I mean, because they're coming in contact with citizens who are expecting, the kind of professional treatment, professional actions that are so important.
Yes.
And they failed. You give us a lot of numbers. I know I read somewhere where the goal was to complete disciplinary cases in a 12 to 18-month time frame. So where are we along that continuum now?
Well, there's so much. When you say complete the disciplinary timeline, that infers that the case has gone through to a decision. So what we can control is up to the point that we file the case. After it's with the Office of Administrative Hearings, if we don't get a trial date until September, that lengthens the process right there. Now, say we go to trial, it's a 1-week trial, so we're through the second week of September. The judge has 30 days to draft the proposed decision and send it to the agency to be adopted or non-adopted. Agencies may not meet every month. Say they get their decision out, so that's going to be October. Say the agency doesn't have a meeting in October. Maybe they don't meet until November or December. You see how the time frame is lengthened, and it really doesn't have anything to do with the Division of Investigation. It doesn't have anything to do with our office, but it's at the Office of Administrative Hearings. And as I say, everyone's been affected by the budget and hiring freezes and the furlough, so I'm sure they're backlogged just like anyone else. For the whole month of April, they're not setting any hearings at all because they're doing the teacher layoff cases. So all the other agencies, they don't handle them at all. They just do the teacher layoff cases during April.
Any other questions? Well, thank you very much for the presentation and for the work that you're doing. Keep up the good work.
Thank you.
Mr. Terrazas doesn't come because you do such a good job. That's what it is.
Thank you, Senator. I appreciate that.
Are you going to run this one? Yes. Okay, next up, we've got concerns regarding the board's enforcement and diversion programs. And Julie D'Angelo, Felmuth,
Yes, Mr. Chair, Phil Meth.
From the Center for Public Interest Law. And you're going to be joined by is it Ms. Katz? Okay.
Good morning, Mr. Chair and members. My name is Julie D'Angelo Felmuth. I'm the Administrative Director of the Center for Public Interest Law at the University of San Diego School of Law. For 30 years, the Center for Public Interest Law has been monitoring dozens of California's occupational licensing boards. We focus heavily on the enforcement programs at these boards. We have participated in enforcement monitor projects at 3 different boards, including the Medical Board, the Contractors State License Board, and the State Bar. We have been active in the legislature and before the boards themselves to encourage the strengthening of the laws and regulations of these boards to better protect consumers and patients. Dr. Katz and I are here today to discuss our concerns regarding the diversion programs for substance abusing licensees that remain at 7 Department of Consumer Affairs boards. The Medical Board had a diversion program for 27 years. During that time period, that program was audited 5 times. I conducted the 4th of those 5 audits. That program failed all 5 audits. And the Medical Board, composed in majority of practicing physicians, voted unanimously to abolish that program because it did not adequately monitor the substance abusing physicians in the program, nor did it protect the patients of those physicians from them. Let's remember who and what we're talking about here. These programs are run by health care boards of the state of California, whose number 1 job is to protect patients. The board knows that a licensee has a serious problem. This licensee is not a casual user or social drinker. This licensee is a confirmed, often admitted substance abuser. Yet the board is allowed to divert this licensee out of the enforcement or disciplinary track, which may otherwise revoke or suspend their license, and into a monitoring program which purports to monitor their behavior and their compliance with a contract that they sign, in which they agree to completely abstain from all use of alcohol and non-approved drugs, and to submit to other monitoring mechanisms that the board might choose to impose. If these programs and those monitoring mechanisms fail for whatever reason, as the medical boards did, that means patients are exposed to health care providers who may be impaired while working, who may be diverting drugs in their workplace that may cause patients irreparable harm. And these are licensees from whom patients cannot protect themselves because most of the time these participants participate in the programs in absolute confidentiality. A couple of points. Not many people know exactly how these programs work, or how they run. Up until 2008, when the Medical Board abolished its program, and in 2009, when the Los Angeles Times published the article that was just distributed to you, a fairly extraordinary article series on the problems at the Board of Registered Nursing's diversion program, very little legislative or executive branch attention has been focused on them. Nobody seems to have a clear understanding of how they work. These programs are extraordinarily complex and fragmented. Each of the 7 boards operates its program differently from the others. Each board contracts out the administration of its diversion program to a large for-profit corporation, currently Maximus, which in turn subcontracts out parts of its job to subcontractors and sub-subcontractors all over the country, such that you've got layers and layers of confusing bureaucracy, all of which is relied upon to assist the state of California in monitoring about 1,100 substance-abusing healthcare providers. The programs rely on numerous private sector people who get paid directly by participants, such as specimen collectors, drug testing labs, and therapists who conduct group meetings. And some programs rely on a large group of unpaid volunteer folks who staff what are called diversion evaluation committees, or DECs. These are multi-member panels of substance abuse experts who assist the boards in evaluating the evidence in any particular case, to assist in determining whether and when and under what conditions a licensee can return to work, and what should the consequences be for relapse. And when a relapse occurs, all of these folks at all of these layers of these programs have to be contacted and consulted in determining what to do about it. So in order for these programs to work, there has to be spotless record keeping and vigorous instantaneous communication among all of these parties and with the board staff overseeing the program. Otherwise, patients are not protected. Which brings up the critical importance of regular external audits of these programs. In order to ensure that spotless record keeping and vigorous communication, you must ensure that these programs are regularly audited by external independent auditors. Up until 2010, Maximus, which has had this contract since at least 2003, had never been audited. As you've heard, the Department of Consumer Affairs audited Maximus because Senate Bill 1444 of 2008 required it to. As you've also heard, that audit was not particularly well done. I share Senator Negrete-McLeod's concerns about an audit that makes an overall conclusion that the contractor is performing to the terms and conditions of the contract when its two primary findings are, A, that the contractor is not collecting documentation demonstrating compliance by each participant with every term and condition of his or her diversion program contract, and B, the contractor is not promptly notifying boards of positive drug tests. That's what the contractor is for. And other important areas were apparently not tested at all in that audit, including the extent to which drug tests are actually conducted on the random dates selected by a computer, or whether they're conducted on dates that the participant can anticipate. That was required by SB 1441. It was a huge problem at the medical board that was documented twice, and yet it does not appear to have been tested in the DCA audit. And then you have the post-audit breach of contract that lasted for 10 months. During a 10-month time period, Maximus's lab applied the wrong thresholds in testing specimens. What that means is that 140 substance-abusing healthcare providers in California who should have tested positive and should have been removed from work immediately were not. Without regular independent audits, all you have is what I saw at the medical board for decades, and that is slick spin presentations about how well the program is working and misleading success rates that are often trumpeted by staff of the program and outsiders who actually make money off these programs. Third, I would suggest to you that an audit of the external contractor is not enough. You also need to require an audit of the board programs themselves. They have never been audited, and some of them are almost 3 decades old. Board of Registered Nursing, Dental Board, there are 7 boards that have diversion programs, Senator. And to my knowledge, none of them have ever been audited. What does the staff of the board do if it gets information from Maximus as to relapse or other non-compliance? How long does it take that board to act? We know that over at the dental board, the diversion program staff can't even share information with the board's enforcement program if a diversioner has flunked out of the program. In BRN's case, the Los Angeles Times found that it takes BRN a full 15 months after a diversion program participant flunks out, is terminated from the program, for that board to even file an accusation against the nurse. That is absolutely unacceptable. BRN and the other boards' diversion programs ought to have a direct pipeline into the Attorney General's office for diversion program participants who relapse. For all these reasons, I completely concur with Director Steger that Maximus should be audited by an auditor outside the Department of Consumer Affairs, and specifically I suggest the Bureau of State Audits. BSA is competent in doing these kinds of audits. BSA audited the medical boards program in 2007. It is currently right now auditing the State Bar's lawyer assistance program for substance abusing attorneys. I also believe that the diversion programs of the largest diversion programs, including BRN and the dental board, should be themselves audited by BSA. Finally, before I turn the mic over to Dr. McCants-Katz, I'd like to present you with one additional suggestion. I've been watching these boards for 24 years. We've been monitoring them for 30. In my observation, it is inefficient, It is ineffective, unnecessary, and unreasonable for each individual board to attempt to maintain its own diversion program. If we must have state-subsidized monitoring programs for substance-abusing healthcare providers, I think it would be better for the department to establish a department-wide program, a single program that is no-nonsense, rigorous, properly staffed and resourced. It is governed by uniform and consistent standards that are applied by staff that are not affiliated with or sympathetic to any particular profession. And this program also must have that direct pipeline into the AG's office for the immediate filing of accusations or petitions to revoke probation when diversioners or people being monitored relapse. In my observation, a department-wide program would be superior to the piecemeal board-by-board approach that we have now, where each program at each board has its own rules and is staffed by understaffed and overworked analysts, and the whole thing is farmed out to a for-profit corporation, which is also staffed by understaffed and overworked analysts who have huge and essentially unmanageable caseloads. So I just present that suggestion to you for your future consideration. Thank you very much for the opportunity to speak with you today, and I'm happy to answer any questions you have, or perhaps you want Dr. McCants to testify first.
Yes, we would. Thank you for your comments.
Thank you.
Yes, Doctor, please.
Thank you for giving me the opportunity to speak before you today. I'm Eleanor McCants-Katz. I am the State Medical Director for California Department of Alcohol and Drug Programs. I'm a licensed physician in California. I'm professor of psychiatry at the University of California, San Francisco. And I am the former medical director of the Virginia Health Practitioners Intervention Program, which is that state's program that's equivalent to what we call the diversion programs in California. I want to make it clear that I don't have any financial stake in the program as it exists in California today. I don't have anything to gain from comments made today. I'm a full-time employee of the University of California, and my employment there will continue after I speak to you today. I simply am making comments due to my concerns in this area and the fact that I do have expertise in this area. I was asked to join the Board of Registered Nursing's DEC and did so in 2008. The BRN has 14 DECs. These are regional committees of volunteers with experience in substance abuse detection, treatment, rehabilitation, and they review individual cases and make recommendations to the contractor and the BRN staff about how to handle particular individuals in diversion. As a DEC member, I was asked to be a case consultant for nurses in the program. I served until February of 2011, at which time I resigned due to my ongoing concerns about how this program was being run by the current contractor. The primary goal of any diversion and monitoring program must be that of assuring to the greatest extent possible patient safety. I don't believe this is possible when the state uses a for-profit company to undertake such a program, and I will provide a few examples of how this is untenable and in some cases dangerous. One, the company appears to have no medical director. The standard for such programs across the country is to employ a physician with experience in addiction medicine to oversee the operations of the program and interactions with clients who can have complex histories and medical needs. It seems obvious to me that the contractor should have known this, and they did not employ a medical director to save money. Two, the contractor is required to pay for the initial assessment of program entrants. These assessments are some of the most difficult and complex of the substance-abusing population due to the impaired health professionals' knowledge of medical conditions, symptoms, and healthcare systems, which can be used to obfuscate the clinical picture. The assessments I received on individuals for whom I was assigned to be the case consultant were often, to be frank, of little assistance due to the cursory nature of the reports provided. I was told by staff of the current contractor that assessments were abbreviated due to the low reimbursement paid by the contractor to the assessors. This prevents contractor staff and DEC consultants to get the full picture of the clinical and monitoring needs of a client. I also questioned the expertise of the program auditors at the Department of Consumer Affairs who audited this contractor. The auditors either didn't review this part of the records of nurses in diversion or were unable to evaluate the quality of the assessments, as this was not noted as a concern in their report. I urge you to consider that just because many pieces of paper required by the contract were present in records of nurses in diversion, this says nothing about the actual quality of monitoring and safety to practice of clients in that program. If the goal of the current diversion program is to make sure paperwork is collected, then the current contractor is doing a fair job, notwithstanding the audit report. If the goal is actual patient safety, I believe this program is quite lacking. Number 3, the company appears to have no in-house medical review officer that it employs specifically to help interpret results of urine toxicology screens of practitioners in diversion, which would use more stringent standards than that of standard MROs. The current contractor has had serious issues with its urine drug screening program being mismanaged, and according to the LA Times, has allowed some to work while using prohibited substances. When the focus of a company is profit, this makes safety secondary and is one of many risks that can occur to the public. The caseloads of the case managers employed by the current contractor is reported to be 100 cases or more, and you can see this on page 16 of the audit that was done of Maximus. This number is far too high for a single case manager to effectively monitor clients. The caseloads should ideally be in the range of 50 to 75 clients. And if a caseload exceeds 75, there should be an active ongoing effort to reduce those caseloads, which will require the hiring of staff. But again, in a situation where a for-profit company has such a program, there's a reluctance to hire more staff in favor of maximizing profits. The diversion programs run by the current contractor are not of the quality that the people of California deserve, despite a very large amount of money being paid to this company. I urge you to sunset this program and reconstitute it in a form that is nonprofit and lacks the inherent conflicts of interest that would occur with any for-profit company running such a program. I want to emphasize that I believe monitoring programs such as you're reviewing today are critically important. These programs assist people who, when not impaired by drug or alcohol use, are excellent clinicians and who provide excellent service to patients. I believe the current program is supported by licensing fees assessed to healthcare professionals licensed in California. I believe that none of these funds should go to a private for-profit company. Any profits from this program should be turned back to assist impaired practitioners who are often financially stressed with the cost of urine drug screens and treatment. This would be a tremendous benefit both to those in diversion and to the people of California who deserve health care of the highest quality. I hope you will consider the good that could be done if our own resources in California, and we have several in the University of California system and the Department of Alcohol and Drug Programs, nonprofit programs that could undertake this important work to improve the lot of impaired health professionals and patients in California. Thank you.
Well, thank you both for your comments and suggestions about how this program can be more effective, not just for those who are involved, but for the citizens, consumers of California as well. Any questions?
Quick comment.
Mr. Vargas.
First of all, I want to thank you for being here, and also as a proud Torero, I always appreciate the work that you've done. I am glad, and I appreciate everything you said. I am glad, though, you mentioned the last part, and that is that, I mean, there is also the issue of second chances for people. I mean, I'm a person that believes deeply in forgiveness and redemption and giving people an opportunity. I mean, these are people who have studied hard and long because they want to do something good in society, and I do think that they deserve at least the chance of the opportunity. So I think that's the context in which you bring this, not the context of people that have made mistakes, not having, just throw them out, but instead monitor and making sure the public safety. So I appreciate what you said. I just wanted to emphasize, though, that second part, at least for me, that's an important aspect also of these programs. I mean, people make mistakes, and they should have an opportunity to redeem themselves and to get their lives back together without creating a public risk for anybody else, of course. But I think it is important to give people a second chance.
And I believe these diversion programs represent a second chance, which is why those monitoring mechanisms are so important to make sure that they're not squandering that second chance, to make sure they are complying with the agreements that they made. And if they're not, there's really no choice. They can't practice safely. They need to be removed from practice, at least temporarily.
Thank you. Thank you.
Well, it appears that we're giving this unnamed contractor a second chance also. I understand there are some discussions and negotiations ongoing. We certainly hope that they will be incorporating many of the concerns and issues that you've raised, and I think that the committee has raised about their performance. But again, we appreciate your comments. Any other?
Mr. Chair.
Okay, thank you.
Thank you.
Thank you, ladies, again. We're going to recess until 1:30, and we shall continue our review of the Board of Registered Nursing, Vocational Nursing, and the Dental Board, and the Athletic Commission. So come back and join us. Thank you.